And as you were observing, Steve, this will be our last Zoom session for Bunsen Burners, Beakers and Bibles at the intersection of science and faith. And tonight, here's our status. Here's the, pardon me, here's the 8 topics that I originally planned. Tonight we're going to cover that item 7. And this is a typo. That should say 4 court cases. I forgot to correct that. So tonight we're going to talk about 4 court cases. I was going to finish on the topic of wonder and worship. And just a couple minutes ago, I tested out a YouTube, both pieces of content I have for wonder and worship are YouTube videos. And I tested one of them just a few minutes ago, and it's really bad quality over Zoom. So instead of trying to play those with you guys online, I'm going to package the links to the YouTube videos, put them in an email to you so you can watch them on your own this evening or at a time of your choosing. But I will briefly do what you'll be looking at. So before we get to our topic for the night, I want to let those in Denver, which is basically Connie and Steve, talking to the Sunday night class. We're going to have a bonus session next Sunday night here at our house. What's that? Oh, there's Ken and Cheryl. Hello. Yeah. Welcome back from travel. Good to see you. So after talking with the Sunday night class, Ellen and I are going to offer a bonus session that's next Sunday evening, November 13. It'll be here at our house, and there's the address. We are going to serve food. Ellen's going to have a casserole in the oven, and if any of you who choose to come want to bring a side dish or chips and dip or anything, that'd be great. If you don't bring food, come anyway. We'll have enough to share. What we have in mind is just to have a little more informal evening together, share some food, and debrief about the class. I'd like to, what is this class? Where's that take you in the area of science and faith? And yes, I can hear you, Turians.
Yeah, unfortunately, we will not be here. I would love to come, Jim, but we're going to be in California.
All right. Sorry, we will miss you. Also this week, I'm going to send out some files by email, notes about the question. This is for your extra reading. If you're curious, I have a short essay about is science faith-based, kind of a tangent topic to our class, but interesting all the same. And I'm going to send out a little 2-page file with some quotes about Bible interpretation. And Doug, one of those is the quote from St. Augustine that you mentioned to the class 1 or 2 weeks ago. So I've got that along with some other notable quotes that I hope will be interesting reading. Fanny, if you'd like to come and join us next Sunday night, we'd be glad to have you with us. Again, before we launch into tonight's topic, I have a correction to make on some information I taught last week. You may remember this slide from last week. I talked about how some creeds, some statements of faith directly address the questions of the origins of the universe and the origins of life. We talked about the Apostles' Creed, Nicene Creed, the early confessions of the Reformation Church. I mentioned Baptist Faith and Mission from the Southern Baptist Convention, the 90 essays from the early 20th century. Well, turns out I was wrong about the fundamentals, so I need to make a correction. And what is that a few of the fundamental essays mention evolution in passing, but one of them addresses evolution directly. It's called The Passing of Evolution by George Frederick Wright. And in short, what Wright does, his beliefs in the early 20th century about the origins of the universe and the origins of life is that, and he accepted the science of geology over long eons of the Earth's history, and he was comfortable that that there were long periods of time. He also embraced a form of divinely guided evolution. Specifically, he believed that animals may well have evolved through a natural process over long. He insisted that humans were not evolved from other animal species, but were specifically the result of a special creation by God. There's more we could discuss about his point of view. It gets fairly complex. I'm not going to go further into it except to notify you that I was mistaken, that the fundamentals, early 20th century, did not address this, and that Mr. Wright's beliefs about origins sort of are pretty similar to the category progressive creation that I match, but it's pretty close to a progressive creation kind of belief. So that was helpful to me, and sorry that I wasn't better informed when I presented that material last week. Okay, well, with that introduction, let's go on to tonight's topic, and let me share a different screen with you, a different window, which is this one. Okay, and the title is correct here: 4 court cases about teaching science. And the introduction is pretty simple and probably no surprise. The internet has led to controversy about teaching science in public schools. And 4 court cases over a period of 8 decades, from 1925 to 2005, have been particularly influential in shaping the legal landscape in the US today. Now, regardless of our personal opinions about these rulings, I think it's valuable for all of us to be knowledgeable about these cases, to be aware of these decisions and how they have shaped the current legal environment in the US. So here's the quick summary, and of course the Tyrians Willers video that we watched together, probably just a couple of years ago, maybe pre-pandemic. But anyway, back on track. The first trial is the Scopes trial, sometimes called the Scopes monkey. And in that year, the state of Tennessee passed legislation called the Butler Act that specifically prohibited in public schools. Well, the American Civil Liberties Union moved quickly to challenge this new law, clearly intending the case to be a show trial and a publicity stunt. And I think I can convince you that they were very successful at that. In particular, the financial support to the ACLU included the newspaper, the Baltimore Sun. Well, why would the Baltimore Sun fund a activity like this? Was it were they concerned about the law, or were they concerned about selling newspapers? I'm pretty sure it was the latter. There were other special interests in this near Chattanooga, successfully lobbied to host the trial in their town. And they were looking for an opportunity for publicity for their small town and for the economic windfall that would come with all the travelers and media who would attend the trial. This is John Scopes. He was an unlikely candidate for this court case because he was a local football coach and substitute teacher. Even though he was not a science teacher or specifically a biology teacher, he agreed to implicate himself and to represent before the court that he had actually taught evolution in a class. Scopes had, strangely enough, Scopes admitted privately after the trial that he didn't really know enough about evolution to know for sure whether or not he had taught it. So it's kind of a funny setup, but he was the person who came forward, was the lead. And he was a celebrity if there ever was one. He was nationally known defense attorney, probably the most famous defense attorney of his day, and an avowed agnostic. And he was very eager to take part in this public trial. For the prosecution, the state of Tennessee that was prosecuting John Scopes, William Jennings Bryan was a famous celebrity in his day. He was a 3-time Democratic nominee for president, lost all 3 elections, but nominated for president 3 times. He was famous for his powerful oratory. In fact, some historians say that his Cross of Gold speech at a political convention late in the 1890s may be one of the best political speeches ever given in the history of American politics. And furthermore, Bryan was a nationally known spokesman for Christianity, and just a few years earlier, he had initiated a nationwide campaign to oppose the teaching of evolution in a perfect individual to take the lead for the prosecution. Another interesting detail about this, to focus only on violation of the Butler Act, but both the prosecution and defense teams spent days arguing the merits of the act, the merits of evolution, and so on. They weren't really interested in whether or not the Butler Act had actually been violated. And John Scopes himself was never called to testify. The 11-day trial was national news and a literal media circus. More than 200 newspaper reporters traveled to this small town, Dayton, Tennessee, to cover the trial. There were even 2 reporters who traveled from London to observe the proceedings. It was also the first US court trial to be broadcast live on national radio. In fact, I think they actually had to string new communication lines, probably telephone lines, to the town of Dayton just to get the radio programming live from the courtroom. It was that John Scopes was found guilty, and subsequent to the trial, the Butler Act was upheld by the state Supreme Court in Tennessee. And this was, in fact, a landmark trial because as of 1925, the teaching evolution in public schools could be prohibited. Even though this was only a ruling, nominally applicable only to Tennessee, what we saw nationwide 25 is that the Scopes trial had certainly a dampening effect on how science got taught nationwide. Other states joined Tennessee, Mississippi, Texas, excuse me, and Arkansas passed similar laws prohibiting the teaching of evolution. There were anti-evolution campaigns in many additional states. And the effect overall was to discourage publishers from including evolution in biology textbooks. The publishers wanted to publish textbooks. They didn't want to publish 2 textbooks, one with evolution, one without. So generally, biology textbooks through the decades of the middle 20th century just kind of ignored evolution, at least high school biology textbooks, I should say. Strangely enough, the teaching of biology all changed after the 1957 launch of the Sputnik satellite by the Soviet Union. Excuse me. The launch of that satellite was a real surprise. It was viewed as a potential threat to the United States, and the space race with the Soviet Union was on. And one of the immediate responses at the national level was science and math education was given greatly increased emphasis. So education or public schools changed because of the Sputnik satellite. And in fact, in the next few years, evolution quickly reappeared in high school biology textbooks. The message and everything began to change. Well, this finishes that interim period, and we're now going to jump to 1968 when our second court case takes place. It was called Epperson versus Arkansas. And in the year, well, way back in 1928, Arkansas passed a law prohibiting the teaching of evolution. And that law stipulated fines and dismissal of teachers. So that's a pretty punitive sort of law. That law was still on the books in 1968. And just 3 years earlier, in 1965, in Little Rock, Arkansas, the school district adopted title right here, if your screen's big enough. They adopted modern biology as the high school biology textbook, and they were requiring teachers in the district to teach the chapter on Darwinian evolution. Well, a biology teacher at Little Rock Central High School, Susan Epperson, was in a bind, and she was concerned about that 40-year-old law that was on the books. And apparently the school district, she took some action. And the very next year, 1966, Epperson collaborated with a state teachers association to file suit in Arkansas to test the constitutionality of that. This case went to local court that year, 1966, and Epperson won. The case was appealed by the state to the Arkansas Supreme Court in the following year, 1967. This time, the state of Arkansas won. And so Epperson and her team appealed to the US Supreme Court, and that case is the name given to this court case, Epperson versus Arkansas. The US Supreme Court ruled that the state law was, in fact, unconstitutional. And their legal basis was they cited the First Amendment of the Constitution, in particular the Establishment Clause, that prohibits the government from protecting a particular religious belief. So in 1968, we have a major change from the Scopes trial decision back in the 1920s. As of 68, teaching evolution in public schools could not be prohibited. And as a little artifact of history, the very next year, this is Susan Epperson, she actually got to meet John Scopes. The two crossed paths at a national teachers convention and got to meet each other. I think that's pretty fun that they actually had that opportunity. Well, after the Epperson decision in 1968, we enter another interim period, and there was still numerous opponents to the teaching of evolution. They developed a new strategy. They turned to representing the biblical creation story as creation science. And several states pursued a, quote, balanced approach of teaching creation science in science classes alongside evolution. Well, it took nearly 2 decades for this to unfold, but it led to a case called Edwards versus Aguillard in 1987, almost 20 years later. It's named after Edwin Edwards, who was governor of Louisiana in that year, when the state went to court to defend a state law that had been passed in 1981, one of these Balanced Act laws. In fact, the title is Balanced Treatment for Creation Science and Evolution Science. The law said if a public school chooses to teach evolutionary science, then creation science must be taught as well. Well, this law was challenged by a man named Don Aguillard, a high school science teacher and assistant principal. He was not acting alone. Again, he was part of a much larger group or team of people that included teachers, students, parents, scientists to challenge this Louisiana law. The case was heard again in 3 different courts, a federal district court, a federal court of appeals, all the way to the Supreme Court of the US. The Supreme Court ruled in this case that the Louisiana law was unconstitutional, and it cited the First Amendment Establishment Clause just as it had done 2 decades earlier in the Epperson case. And in making this ruling, the Supreme Court concluded that creation science was religious belief and not science. So this is our 3rd step in this little legal journey. As of 1987, teaching creation science is now prohibited in public schools. So we enter another interim period. This is going to turn out to be almost another 2 decades. In Edwards versus Aguillard stated that alternative scientific theories could be taught. So in the decade of the 90s, the anti-evolution activists began to focus on intelligent design as science to be taught alongside evolution. And as you might expect, this eventually came to a head and gave us the court case called Kitzmiller versus Dover, Pennsylvania Area School District. In particular, this is 2005, about 18 years after the Edwards case. Now, in Dover, Pennsylvania, the local school board required the reading of a brief statement to every 9th grade biology class. And that statement expressed uncertainty about the theory of evolution. It offered intelligent design as an alternative scientific explanation of life. And the brief statement informed students that an alternative textbook was available in the classroom for those who wanted to better understand intelligent design. So it's interesting, it was a fairly benign kind of thing. They weren't actually teaching intelligence, but they did read the statement and they had this alternative biology textbook available. Well, that didn't sit well with some in the community, and 11 parents of high school students sued the school board to revoke this policy, and that became Kitzmiller versus Dover. For one, it lasted 6 weeks. It was heard in a local court, and in the end, the judge ruled against the school board. As a consequence, the brief statement could no longer be read, and the alternative textbook. The proceeding took 6 weeks because there was extended testimony from both sides on the question of whether the idea of intelligent design should be treated as science or not. And in the end, the judge in the courtroom decided it was not science, and he cited the same legal precedent that we've been talking about, the Constitution's First Amendment Establishment Clause, as had previously. And he concluded that intelligent design was religious belief, not science. So this is our 4th step in the journey. As of 2005, teaching intelligent design as science is prohibited in public schools. So I'll just wrap up by observing that all 4 of these cases have pitted Christians against atheists or agnostics against Christians. It's just another example of how this question of origins of the universe and origins of life remained disputable issues to Christians, because there were devoted Christians represented on the legal teams on both sides of all four of these cases. And I think the key takeaway is that under US law, both creation science and intelligent design have been ruled to be religious beliefs, not science. Here are a couple references. And as I alluded to when the Turians came on the Zoom meeting, this class tonight is primarily inspired by a Kenneth Miller lecture. It is available on YouTube, so you'll get this link if you want to watch his original lecture about these court cases. Professor at Brown University. He's a Christian and a lifelong Catholic. And he got involved in this whole scene because back in 1990, he became a co-author of the leading high school biology textbook in the US, still today, and it's called Biology. It's in its, I forget, third or fourth edition, but Dr. Miller is still a co-author, and it's still an active, up-to-date textbook series and the leading high school biology textbook. As a consequence of that authorship, Dr. Miller was the first expert witness to take the stand in the Kitzmiller versus Dover trial. In that trial, he learned all about the legal history of the other three cases that I've summarized tonight. He did a great recorded lecture, so there's another source. Another source you might be interested in looking at is that the Kitzmiller trial, the last of the four, an hour-long documentary back in 2007 called Judgment Day, Intelligent Design on Trial. If you'd like to know more about the Kitzmiller trial, that's a good